Welcome to our business track of the Data Science Salon YouTube channel. This is a presentation by Brandy Walsh, data privacy attorney at Acxiom. Her talk demonstrates that as we progress into the privacy unknown, we must continue to balance economic and business necessities with consumers' rights. In order to do so effectively, we must first understand where privacy as a legal concept originates. This interactive and informative session will explore the evolution of privacy law by tracing privacy's origin through landmark Supreme Court decisions, legislations, and social trends that shape the world of data privacy as we know it today. Enjoy this presentation.
Thank you so much for having me today. I'm really excited to be here to talk to you guys about data privacy law and its evolution in the United States. And it's really interesting to have a combination of finance and technology folks here today because the finance people are probably already glazing over, thinking about their various privacy laws that regulate their industry within the United States, such as GLBA, FCRA, and so forth. And the technology folks are probably here thinking like, okay, what's going on? I don't know. So hopefully we can bring the compliance issues unique to each industry all together during this discussion today. And to do so, we're actually going to take it back to the very beginning of privacy law in the United States with a man named Mr. Katz, and that's with a K and a Z, so Mr. Katz. So the year is 1967. And while I wasn't alive back then, I do know that the federal government didn't love gambling. And on a flight last year, back when we were able to fly and move and go to conferences in person, I watched a show, or I watched one or two episodes of the in-flight show, which was something called 11/22/63. And I think it's on Hulu, and I can't vouch for the show, so please don't take this as me, promoting the show. I don't know. I only watched the first two episodes. But one of the scenes, so it's set in 1963, and one of the scenes is the main character who goes back in time, and he goes to one of these gambling dens, probably exactly like Mr. Katz did in 1967. And it's very dark. In there, there's a lot of cigar smoke and a lot of hair gel. Just a lot of, everyone has hair gel to an extreme amount. And this is actually how the main character makes money. So he knows who's going to win the fights and he does the gambling. But everyone is worried that he's a cop because, they didn't love gambling back then. So that's my mindset when I set this case up and how the United States really kind of began the discussion about privacy law that affects so much data science, finance, and technology today. So that's my mindset, and I imagine that's what Mr. Katz looked like. Maybe less hair gel. I don't know. So back to the nonfiction now. So it's 1967. The federal government has a suspicion that this man named Mr. Katz is transmitting gambling information across state lines using a public phone booth. And again, full disclosure, while this is my absolute favorite case in law school, and it definitely kickstarted my career in privacy law, I've never used a public phone booth. I don't even know if I've seen one in person. They don't look very private. The other picture that I had before, they were within inches, you could probably reach out and touch the person next to you. But nevertheless, the federal government decided that they were going to wiretap the phone booth that Mr. Katz used frequently. I guess he had a phone booth that he frequented to make these gambling transmissions. They were going to place an eavesdropping device on the outside of the phone booth and try to collect evidence about his illegal gambling. And so they did that, and through that eavesdropping, they were able to obtain enough evidence, enough conversation that they were able to indict him on illegal transmission of wiring information. And so then through appeals and various court processes, the case made its way to the Supreme Court, and in a 7-1 decision, the court found in favor of Mr. Katz. And this was the very first time that we really see the court say, okay, the Fourth Amendment, which protects us against searches and seizures, unreasonable government intrusion, it protects people and not necessarily places. So even though Mr. Katz was in public, he was in this phone booth that was not his private phone booth, it was out on a street somewhere. He himself and his conversations were protected from, he had a reasonable expectation of privacy when he was in that phone booth. And so this is really one of the very first times we see the Supreme Court decide that people, their likeness, their conversations, they're protected, regardless of where they're at to a certain extent. Now, there are a handful of other cases that are just absolutely equally as interesting, if not more interesting, than this one, sort of how it evolved over the next decade or so. But we definitely don't have time to get into that today. I think there's a lot more relevant conversation we can have now. But this is the idea of, I like to say, this is what I tell my kids at bedtime, their bedtime story is Mr. Katz. No, privacy started in a phone booth and now it's, on our mobile devices, right? Really, it started in a phone booth. So where are we today? Okay, we're right here. As you can see, I have a lot of acronyms on the screen. And some of these will be familiar to you, particularly the finance folks on the phone. So the FCRA, passed just a few years after Mr. Katz, his case, and then GLBA in 1999, so a couple of decades after that. But basically what I'm trying to show here is that for a very long time, the US has been, and quite frankly it still is, just kind of a patchwork model of privacy law. So where your attorneys have to remember not only all of these acronyms and what they stand for, but also how they apply to various data sets that you may be processing. It's a challenge. It becomes very apparent too when you look at my second bullet there, the foreign laws, and kind of contrast that with the US. So foreign jurisdictions are a little bit better, a little bit more advanced than the US in their implementation of uniform privacy laws that apply to consumer data and consumer data processing. I would also like to point out that in addition to all of these acronyms, in 2019, there were 150 bills introduced at the state level in the United States that spoke purely to privacy. So forget everything you know about data security. It had nothing to do with that. 150 bills just talking about data that relates to consumers and how it's processed by companies. So we're basically in a melting pot of acronyms, and potentially it could get a lot more confusing before it gets any clearer. But because it's a patchwork, it actually leaves a lot of companies in the technology and data industry looking to comply with industry-specific self-regulatory organizations, as well as the terms and conditions that govern a lot of the device identifiers and information that we use today. So, for example, you may be familiar with the announcements that Apple and Google have made this year with respect to their specific identifiers, so the IDFA and the third-party cookie. The third-party cookie is going to be going away soon, and the IDFA will be opt-in only consent-based approach. But one commonality between sort of the patchwork of law that we have here in the US is that most people are pretty comfortable in their understanding of what is covered. And by that I mean that these laws sort of, they cover traditional personal information, but it's segregated by industry. So like HIPAA covers health information. You're probably familiar with that from your doctor's office visits. GLBA, of course, the financial information. But the personal information defined and referenced in these laws, it's pretty common. It typically means, name, address, email, sort of that traditional, comfortable information that everyone kind of looks at and says, oh yeah, that's personal information. So that's what we've had so far. And this is where I want to call some attention to the middle acronym there, just kind of wedged in between the others, the CCPA and the CPRA. So these guys, they're special enough that they get actually a couple of slides dedicated only to them. So CCPA and CPRA They're the California Consumer Privacy Laws. And CCPA came first, and by now you've probably heard of it. Maybe you've read about it somewhere. You know that it's something that the U.S. is dealing with now. It went into effect at the beginning of this year, and CPRA is the ballot initiative that passed in November, on November 3rd. It amends CCPA. So if that sounds confusing, that's because it definitely is. But the important thing to draw out for this session is that CCPA is really the first time that those of us in the technology sector have had to look twice at a law and actually spend quite a bit of time determining whether it applies to specific data sets or identifiers that we're processing. As you can see on the screen, the definition of personal information under CCPA and CPRA is extremely broad. It's actually much broader than what I have pasted for you on the screen. But I've pulled out the explicitly listed identifiers, so you could have them for your reference and take a look at some of these identifiers. So we have the obvious stuff that we just talked about, like name, address, email. And then we have the stuff that you're like, wait a second, what? Am I reading this right? Cookies and mobile ad identifiers, so the AAID and the IDFA, even pixel tags. Usually, this is stuff we consider anonymous, and now it's going to be defined personal information under CCPA. The most important thing to call out is that CCPA includes basically any device or consumer persistent identifier. So if you have a device that persistently relates to a consumer, if you have an identifier that persistently relates to a device or a consumer, you're probably dealing with personal information under CCPA. So in a way, CCPA and CPRA kind of merge the realm of sort of the familiar, the offline, and sort of the digital online stuff we thought was anonymous, right? It brings the law kind of full circle. So the biggest shock, though, is that all of these identifiers that we were processing previously under the assumption of sort of anonymity no longer are considered anonymous. And this is a hard pill to swallow. It's definitely something that I have to talk with my data scientists and engineers about daily to explain. And at Acxiom, I'll tell you, we're even considering the idea that an encrypted iteration of one of these persistent identifiers likely wouldn't bring it outside of the purview of CCPA, particularly where the underlying algorithm for the encryption or even hashing isn't regularly changed or updated, because you ultimately have a persistent input-output. That really doesn't go over well with my data scientists and mathematicians. So it's definitely sort of new concepts that are a bit of a shock to our industry. All of that said, though, where you sit squarely in the finance industry and you collect information, personal information pursuant to GLBA or the California Financial Information Privacy Act, you don't have to worry about additional compliance with CCPA. So that may be a relief for some of you here today. So like my boss always says, so what's the big so what? Like, what does this mean? Why does it matter to me? What does it mean that CCPA may apply to the data that you're processing? So let's talk about some of the requirements. The biggest requirements are that companies must provide individuals with enhanced notice of data collection, as well as an opportunity to opt out of sale, and an opportunity to have the data actually completely deleted from the processing environments. And so this can be a bit difficult for covered businesses and organizations that don't have a first-party relationship with the individuals of whom they're processing data. And one compliant way around this right now under CCPA is to register as a data broker in California. And that may sound like, well, we're definitely not a data broker, but again, it's very broadly defined, meant to capture as many organizations as possible. That may not be the case under CPRA. We're still waiting on those regulations. Of course, who knows how long it'll be until we get them, honestly. But giving consumers notice that you're collecting the data or processing the data is one of the key requirements. The other tricky requirement is the right to access. So this means that individuals should be able to come to your organization and request to know what information you hold about them. And this can really turn into an engineering overhaul, particularly when you start thinking about like unique processing environments, and as well as what is actually considered personal information. You know, like I mentioned on the previous slide, it may be a lot more than what you initially thought. CPRA that just passed in November, it doesn't change much in terms of these requirements. These are mostly preserved, but most notably, it adds the right to correct. So this means that if a consumer comes to access the data you hold about them, or to see the elements that you hold about them, and they find it's inaccurate, they can actually request that your organization correct the inaccurate data within your environment, which again can be a pretty big engineering overhaul, particularly as you think about data flows where maybe some are interdependent, right? Maybe some data flows feed into others, but then some are siloed, and you may actually have to go in and manually change data. So there's a lot to unpack here. They both definitely change the compliance scene. They're not going away. Don't delay compliance. It's probably only going to get, I don't want to say worse, but it's definitely going to get more. Like we'll probably see something at the federal level within the next 4 years. So don't delay compliance, hoping that it goes away. Because I did that for a year, but I think at this point it's here to stay. Okay, so the purpose of this presentation overall is really just to open your eyes to laws that may apply to you that you may not be aware of. But I'm also going to give you a little bit of a homework assignment. So as it relates to AI in particular. So CPRA introduces a new concept, which we don't have in CCPA, and I'm not actually aware of it in any of those other acronyms in the US. Now I know the European Union has something similar to this under GDPR, but certainly not in the US this extensively. So CPRA introduces a new concept, which I've defined on the screen here for you. And it may, the processing may look familiar to some of us, maybe many of us on the phone to here today. And maybe it's similar to processing you do daily, or something you're looking to implement after this workshop that we're doing. So I wish I had some good information to give you. Right now, there really isn't a lot of guidance around what will be required with respect to companies engaging in what CPRA defines as profiling. The clear text of the law mentions it, it defines it, and it basically says we're going to promulgate regulations that will tell you what to do. There's going to be a new agency created in California that will promulgate these regulations that will give guidance around sort of perhaps the necessary access and opt-out rights for businesses using automated decision-making technology. But right now we don't know for sure. This is definitely a good time to go to your legal team, your compliance department, and be prepared to share your processing and data flows and automated decision-making technology, so that they can begin to assist you in ensuring your compliance under this new law. Now, the good news is that CPRA doesn't actually apply to data collected before January 1st, 2022. So we have a full year to get compliant. But it is still a good time to go in and get your legal team on board with what you're doing and how you're processing. Okay, so this has been a lot of information today, and I really hope I didn't send anyone into a panic or leave you more confused than when you joined, or let it go in one ear and out the other. So I've identified some questions to consider when determining whether these new laws, particularly in California, might apply to your processing generally. And this may help you determine which data flows or which environments you need to take to your privacy or legal or compliance team. But I would say, when in doubt, go talk to them. They're there to help you and the company maintain compliance. So my first question in every single privacy impact assessment I analyze is, does this data flow, this processing, does this involve an identifier? And that's really key when we're trying to determine whether we're dealing with personal information under CCPA. And I have some very savvy engineers who will very much work their way around to giving me an honest answer without giving me all of the information. So for those, I have to ask, is this a persistent string of characters unique to a consumer or device? And if the answer to that is yes, you're dealing with an identifier, you're most likely dealing with personal information, and CCPA most likely applies in some capacity. So if you remember a couple of slides ago, the list of covered identifiers is lengthy and all-encompassing, and it brings in those anonymous identifiers that we were working with previously under sort of the concept of anonymity. So it is important to identify where you're working with an identifier. I will say, though, that aggregate consumer information falls outside of the definition of personal information under CCPA, but it's very, very narrow in that it cannot just be one or more consumer records that have been de-identified. So Acxiom has taken a somewhat conservative position in a lot of our analyses around this. We've concluded that groupings consisting of less than 5 individuals or households is likely small enough to still be considered personal information. So where we may be processing in a smaller group, we would consider that personal information, and we would apply all of the CCPA requirements. And where we're processing maybe a much larger amount, we would double check, whether we needed to apply. The overall point is, where you have a persistent identifier, there you also likely have personal information under CCPA. But let's talk about de-identification briefly, because I know a lot of data scientists and processors rely on this, just generally, even without thinking about compliance. And this is a concept that our engineers love to implement as a compliance measure as well. It's definitely not easy to do. So the new definition of de-identification under CPRA essentially precludes any downstream or subsequent re-identification. So this means you can't encrypt or obfuscate an identifier in one environment and then permit a downstream external or internal user to decrypt or otherwise convert that information back to personal information, which really limits sort of your use of de-identification. Basically, once de-identified, it can never be undone. And that really limits practical use, particularly from a marketing perspective. So in those instances, you would arguably be completely subject to all of the requirements of CPRA and CCPA. But this almost absolutely rules out sort of encryption to alleviate those obligations, which is one of the reasons Acxiom doesn't rely on it. So once I get through all of that with my engineers and data scientists, my second question is, are you processing or matching based on a regional identifier or a regional grouping, like a zip code or maybe a census level data set? So there is case law in California, which is kind of the state that matters for all of this, but we do see it becoming sort of the national trend. We see states mirroring CCPA. So it's not just California. Some people are like, hey, I'm just going to remove all my California data and then I don't have to do any of this. It's like, well, maybe hold off before you do that. But there is case law that supports the idea that a 5-digit zip code is actually personal information. So that's a tough conclusion when you're working with zip level data. But it's just important to think about, where it includes demographic data, like maybe race or gender. The more of that exists within your regional grouping, the more likely you're dealing with personal information, regardless of the level of aggregation. So something to keep in mind. That would be a great question for your legal team. Maybe see if they can find the case that talks about zips being personal information in California. Okay, so the last point I want to talk about with questions to consider is the use of data access via SDK. So even outside of CCPA, when we go back to that first slide where it had the sort of the industry codes of conduct and the the hodgepodge laws that we have here in the US, SDKs are very tricky from a compliance perspective, and where the data is flowing from between the parties is very tricky. So where you are using an SDK for development of your application, particularly mobile applications, certain data points derived from your app are, of course, available to the SDK provider, typically through tracking implemented within the code. And often I've noticed, just from reviewing them over the last few years, the end user license agreement that you maybe click through, or that you sign, or maybe you accept when you sign up to use the SDK, there's usually language that basically provides that SDK provider the legal right to not only collect the information, and data from your application, but also to use it, and in some cases even sell it, all derived from the users of your applications. So if you are an SDK provider, some of the information you're getting back from the application could be subject to CCPA. But overall, data accessed in this manner is about to become really interesting, because you're probably aware of the iOS 14 update and sort of the implications. I mentioned it on one of the first slides with respect to the IDFA, as well as any information collected from the app. So it actually puts the onus on the developer to ensure they are aware of the data collection and transfer between the two parties. Okay. Finally, some recommended best practices before we open up to Q&A. Implementing a solid data governance program is really the best way to get ahead from a compliance perspective, especially the patchwork law that we have. Eventually, it will resolve to something at the federal level, but having documented policies and procedures that govern your handling of data in various environments will only set you up for success. So, of course, you can't have policies, though, until you've identified and documented the various processing environments within your organization. And one way to do this would be to label them, those that include personal information under the new CCPA guidelines, and those that don't. And data classification. So this is also important for, number one, labeling those environments, but also CCPA actually requires covered businesses to list all of the categories of personal information that have been collected over the last 12 months. And of course, data tagging can assist in your ability to search and discover, which is particularly important in the event of an audit or regulatory inquiry when everyone's kind of panicked anyway. It's just good to know what you have, where you got it, what governs it. So overall, data governance is very, very important and will set you up for success. So that concludes my content today, and I think we're going to open up now the Q&A portion of this session.
That was a presentation by Brandy Walsh, data privacy attorney at Acxiom, on exploring the evolution of privacy law by tracing privacy's origin through Supreme Court decisions, legislation, and social trends that shape the world of data privacy as we know it today. If you enjoyed that presentation, please make sure to subscribe to our channel below.